Good afternoon and Happy New Year to all. Welcome to the Afridi Angell webinar. My name is Samira Amari and I'm the Head of Business Development and Marketing at Afridi Angell. Our speakers today are partners Charles Loback and Danielle Lobo. Charles is our most senior partner at Afridi Angell. He's a corporate partner and his practice includes general corporate, M&A, restructuring, regulatory, and employment law. Danielle is also a corporate partner and focuses on private equity transactions, M&A, joint ventures, and restructuring. Today's webinar will cover amendments to the UAE Companies Law, compliance with economic substance, AML, and UBO regulations. Charles and Danielle will also go through some of the most recently asked COVID-related questions. We will not have slides today. It will be a straight presentation, live presentation by Charles and Danielle. Before I hand over to Danielle, who will kick off with the company's law discussion, I want to mention that everyone will remain muted throughout the webinar, and you can send your questions, and please send your questions throughout the webinar on the Q&A box. Charles and Danielle will do their best to address all questions received within the hour. Thank you again for joining us, and thank you to the ACC Middle East and the Canadian Business Council Dubai and Northern Emirates for collaborating with us on this webinar. Over to you, Danielle.
Thanks, Samira. I'm going to start off, as Samira mentioned, discussing the amendments that have taken place to the 2015 Commercial Companies Law. And they came in towards the end of last year as a result of Decree Law number 26 of 2020. Now, the amendments were essentially bagged into two categories, amending over 50 provisions of the company's law. The first batch of amendments was stated to have effect on the 2nd of January of this year, whereas the second batch of amendments are stated to take effect at the end of March this year, and that being 6 months after the publication of the decree law in the official gazette. Now, the first amendment I am going to talk about is the amendment that really caused a lot of excitement within the UAE amongst investors and the media alike. And that was the deletion of Article 10 of the company's law. Now, Article 10 of the company's law provided that an onshore LLC must be earned 51% by UAE nationals. The position under the decree law is that article has been deleted in its entirety. And the decree law has set out some steps for the implementation of a new regime. Now, what those steps are is that firstly, a committee is going to be formed. That committee will be made up of representatives from the various economic departments. The committee will discuss and decide upon activities that are considered to have strategic effect within the UAE. These activities will be published by way of a resolution, and then what will happen is it will be down to various emirate level regulators, so the economic department in Dubai and the economic department in Abu Dhabi, for example, to implement the regime. So they will decide upon the percentage UAE national ownership requirements of these activities which are deemed to be of strategic value within the UAE. And the interesting point there is that because it will be left to emirate level regulators to decide upon this, you could of course have a difference in percentage ownership requirements between emirates. So that will make it particularly interesting when it comes to setting up of a group in the UAE where entities are set up in more than one emirate, or when we're looking at restructuring of entities. So the way it stands at present is that the restriction has been removed, and therefore the general position is that up to 100% foreign ownership is in principle permitted onshore in the UAE. The question is just to wait and see what this strategic list of activities is going to look like, and that will really determine how widespread this change is going to be for investors in the UAE. The other thing to note, which a lot of commentators have discussed, is really how the free zones will fare if this amendment is going to work out and to be as wide-ranging as it's anticipated to be. Now, I think for various free zones which have unique offerings, such as the financial free zones or free zones with access to ports, it's likely that they will still continue to be popular. But the question remains as to whether, for example, Dubai has over 40 free zones, as to whether those free zones will still be as popular if foreign investors can come onshore and invest in higher percentages. It will also be a really important change in terms of not only investors coming into the region, but also for M&A activity. Depending on the list of strategic activities, it will hopefully mean that there are more exit opportunities available for companies, and it will hopefully increase the potential purchases of onshore entities in the UAE. So that's really where we stand at the moment in terms of that amendment. Now, I wanted just to also mention very briefly some of the other changes that have taken place in the decree law as they relate to LLCs. Firstly, you should expect there to be a corporate governance regime coming into play in the near future for LLCs. And under the decree law, that regime must be administered by the manager or managers of the LLC. We're also expecting further guidance on sole shareholder LLCs, how they can be formed and how they will operate in the UAE. Also, there have been quite a number of changes to the holding of annual general meetings for LLCs. Firstly, an annual general meeting can now be called by 10% of the partners of an LLC. So 10% of the partners can request a meeting to be called. Under the old regime, that was set at 25%. Also, what has happened is there's been a retreat back to the pre-2015 regime, in that LLCs are now required to give 21 days notice of an annual general meeting. This was changed to 15 days under the 2015 law, and the longer period of notice has now once again been adopted. The quorum requirements have also changed, such that if at your first annual general meeting you do not meet your quorum requirements under your MOA, you will hold a reconvene meeting, and at that reconvene meeting, the meeting will be deemed to be quorate. So there's only a requirement now under the new decree law to have one additional meeting if the first one is not quorate. Another amendment for LLCs, and really I guess a sign of the times and the events over the last year, is that a partner of an LLC can now apply to court to have a waiver of preemption rights which are prescribed under law. And this is in circumstances where it's to permit an LLC to have emergency funding invested by another partner. So if the company is in some sort of financial distress. And also a small point, but it has been clarified under the decree law that all memorandums should have dispute resolution mechanisms provided within the memorandum. Most of the memorandums we see these days do have that, but now it is something which has been included within the decree law as an essential provision. All of those amendments that I've just mentioned are already in force. And so there's really a question as to, and we've been advising clients as to what they need to do in order to bring these into their constitutional documents. Now, under the law, you have a period of 1 year, so that's until the 2nd of January 2022, to bring your company into compliance with the new provisions. As most of you will remember, when the 2015 amendments came into being, due to the lack of amendments made to memorandums to comply with the 2015 changes, what essentially happened was that those changes were deemed to be incorporated into your memorandum. There isn't currently a provision like that under the new decree law. So what we are advising clients to do is, if they are amending their memorandums for another reason, to obviously take into account these new changes that have come into place. And if they aren't, just over the next year, review constitutional documents, understand what changes might need to be made to them with a view to implementing during this year grace period. And just one final point, which the decree law brought in, but which will be important for foreign companies that have branch offices and representative offices here. There is no longer, or there will no longer be, I should say, a requirement for these branch offices or representative offices to have a local service agent. And that amendment will come into effect at the end of March this year. Charles, can I pass over to you?
Well, certainly, yeah. Thanks, Daniel. Thanks very much. That was a very quick rush through the company itself, and it's a big topic covered in about 16 minutes and 20 seconds. So thanks very much for that. But the past 18 months has seen a lot of very major changes here in the UAE, and I'm going to talk about a few of them. But I hope all of you out there realize that this is not a replacement for getting legal advice on what to do. The changes are very far-reaching. They're very complex. The pace, I think, if anything, is picking up. So it's a good time to be a lawyer, I suppose, because the kind of work we do is keeping us really busy to stay on top of all of these things. But I'm going to talk about a few topics as well. There have been some important changes, and I'm going to talk now more in the compliance sector, not the compliance field. The one topic are these new economic substance regulations. I'm not going to go into great detail. We did have a panel on this about just over a year ago, also for the ACC, and we went into them in some more detail. I don't talk about it in general. They were introduced by Cabinet Resolution number 31 of 2019, and they basically apply to corporate companies, to businesses in the UAE that are engaged in what is called by the regulations a relevant activity. And I apologize that there's a list of them, 9 of them: banking, insurance, investment fund management, lease finance, headquarters, shipping, holding company businesses, intellectual property businesses, and distribution service centers. Okay? Now, if a company is in one of those sectors, one of those relevant activities, then the business is required to do 2 things. One is to make an ESR notification to the regulator. Depends on if you're onshore or on the free zones, but you make a notification to the regulator within 6 months of the end of the business's financial year. And then you also make an ESR report you file with the regulator within 12 months of the end of your financial year. Now, since the regulations came into effect in 2019, you're basically supposed to file an ESR notification and an ESR report in respect of the financial year that ended on 31 December 2019. Now, that deadline, of course, passed some time ago. It's been extended, and so the filing deadlines for both of those, notification and report, are the end of this month, January 2021. And then the 6-month, 12-month kicks in again with regard to financial year 2020. So if your financial year is a calendar year, those are your deadlines. You do have to disclose in some detail the nexus between the business activity and the United Arabs to show you're doing something in the country. And in fact, we've had clients that have restructured their activities and got different licenses, changed their licenses so as to more easily comply with the ESR. If you don't comply with the ESR regulations, if you miss a filing deadline, there are penalties, there are fines, and if you make a report that shows you're not complying with the substantive requirements, there are also penalties. So it's a fairly serious bit of regulation. It came in kind of new, but companies are complying with it. A second set of regulations that has been actually in the landscape for quite a long time, but is becoming more and more important in the sense that it's becoming more generally applicable, are the regulations on anti-money laundering compliance. Now, if you've been in the UAE for a while, you'll know that companies like banks and insurance companies have been having to comply with AML requirements going back to the early 90s at least. But now what has happened is that the most recent iteration of the AML regulations are making the requirements to have an AML compliance policy and to generally comply with the regulations apply throughout the UAE economy. It's not just silos of financial services companies like banks and insurance companies and accountancy firms and lawyers and so forth, but it's across. In fact, the Ministry of Economy has sent a circular around to all designated non-financial businesses and professions, DNFPBs, okay? Which is a real nice AML term that is used in other parts of the world. Now it's being used here. And those DNFBPs are supposed to show to the regulator, the Ministry of Economy in this case, that they have AML compliance rules in-house, that they have rules on, number one, avoiding handling funds that have perhaps suspicious origins, making sure you have robust KYC requirements for dealing with clients and suppliers, making sure you have training for personnel, making sure you have requirements to notice and report to the authorities suspicious transactions, and all the rest of that. And again, there can be fines, not just for violating the money laundering requirements themselves, but for failing to have these kinds of procedures in place. The law is Federal Decree Law 20 of 2018, and the most recent, but of course that just replaces earlier laws. The regulations are set out in Cabinet Resolution 74 of 2020. Where are these things coming from? They're coming from, as you can perhaps tell by the way that they're approaching these topics, a couple of things. It's mainly foreign regulators are concerned that the UAE doesn't have enough visibility or transparency on ownership and compliance matters like this. And so there is some pressure coming to bear on the UAE from overseas to develop these kinds of requirements. The anti-money laundering regime in particular has been pushed by an organization called the Financial Action Task Force, FATF, which is a multinational organization composed of banks and regulators that are trying to achieve uniform compliance with these kinds of rules throughout the world. There have been now several dialogues between the FATF and the UAE. The most recent one was completed last year in April, if I recall correctly. There is a very lengthy mutual evaluation report, which you can see if you Google search UAE FATF. And then it's quite long, it's several hundred pages, and it goes into great detail about the kinds of, the way the UAE regulates anti-money laundering compliance and the kinds of recommendations that FATF has put out there for the UAE to address. So these are very real requirements. Compliance is being required in more and more businesses across the UAE. You can assume it applies generally to everybody. And there will be sanctions have been imposed already in some of the financial free zones and DIFC in particular for failure to comply with AML requirements. But I think we can see sanctions will be imposed on other parts of the economy going forward as well. So it's part of the legal landscape that is changing, and where I think there's going to be a bite coming up too. So that's a very quick snapshot of what's happening. Also under the AML law, which I said is Federal Decree Law 20 of 2018, the Cabinet has also promulgated regulations on ultimate beneficial ownership, okay? And with that, the UBO topic, I want to hand back over to Danielle, who will tell us what that all means. Thank you, Danielle.
Thanks, Charles. Yes, as Charles has said, it really sets the background for this topic on the UBO regulations, which I'm going to discuss. They stem out of the federal law on anti-money laundering. And as Charles has said, this is really coming to being, this whole regime of law, as a result of the FATF interaction with the UAE. Now, the UBO regulations came in late August. It came in under Cabinet Resolution 58 of 2020. And under those resolutions, entities are required to, amongst other things, maintain a register of ultimate beneficial owners. Now, this resolution applies to entities across the UAE, whether in a free zone or onshore, with the exception that it does not apply to any entities incorporated in the financial free zones. And that's because, as I'm sure all of you will be aware, the DIFC and the ADGM have its own regime on UBO requirements. Now, a lot of free zones, even prior to the issuance of this Cabinet resolution, were already requesting information on ultimate beneficial ownership of entities registered within the various free zones. This Cabinet resolution was really brought about in order to standardize the information that regulators are requesting. Now, in terms of other exceptions from the applicability of this resolution, it doesn't apply to any entities which are indirectly or directly owned by the government. And as I said earlier, it doesn't apply within the financial free zones. Otherwise, your entity does fall within the purview of these resolutions. Now, what is a beneficial owner? The resolution states that beneficial ownership is triggered at 25% or more of the capital of the company, or if you have control of 25% or more of the company by other means. So, for example, by being able to control the board of directors of the company. And each entity is required to not only maintain the register, but also to submit the register to its relevant authority which governs that entity. In addition, if there are any changes to ultimate beneficial owners, they have to be updated in your register and also notified to your registrar within a 15-day period. Interestingly, the resolution states that if there is going to be a transfer of shares in an entity, what needs to happen is that before the company approves any transfer, the transferee has to indicate whether that transfer is going to result in a change of beneficial owners, and if so, of course, the registers have to be updated. Another thing to note is that on liquidation of a company, liquidators are obliged under the resolution to notify the relevant registrar and provide the registrar with a copy of the UBO register within 30 days of their appointment. In terms of record keeping, under the resolution, even where your company has been dissolved, there is a obligation on management to maintain copies of the registers for a period of 5 years after dissolution. So it's one to bear in mind that it's not just once you dissolve the company, you fall away from the ambit of this resolution. You still have those record-keeping obligations. Now, practically, what we are seeing really across the different registrars is that they're all at different stages in terms of being able to accept submission of UBO registers. At the Economic Department in Dubai, they are accepting registers, and we have been filing them on behalf of clients. I believe Abu Dhabi is still not quite there yet, and certainly a lot of the other free zones are have started to implement and have started to accept the submission of registers by their licensees. One thing to note, which is confusing for clients, and questions have been raised where clients have entities across different free zones or onshore as well as in a free zone. Sometimes the requirements differ from what is set out in the resolution, and of course the registrars in the various free zones or onshore have complete discretion to request additional documentation or information as they see fit. So really, practically in terms of this, when it first came out, the resolution essentially was stated to have effect pretty much the next day, and so there was a lot of concern from clients as to what they need to do. What we have been suggesting is that where your registrar, so your relevant governing regulator, has not implemented a method for you to submit your register, you should maintain that register at your registered address as is required by you under the resolution, and just keep abreast of any developments as to when your registrar is ready to accept submission of the register. So that's really the practical position there. Now I'm going to pass you back to Charles.
Thanks very much, Danielle. Thank you. I wanted to talk, and maybe briefly, but maybe not so briefly, I guess we'll see, on some topics that are coming to us, and I think to a lot of you out there as well, as a result of the current COVID crisis. So let me just talk a little bit about last year when the COVID crisis hit. The authorities took a number of measures to try to enable businesses to keep on operating to the best extent they could, and to do things like retain talent if you can. I guess the biggest threats to the UAE were things like the prospect of the economy was shut down completely, and we'd be in negative growth, and that when it was time then to restart the economy, everyone that can restart the economy would have left and couldn't come back. And the authorities have done a pretty good job in avoiding those two very, very negative consequences of the COVID crisis, which unfortunately we didn't have to deal with. And now with testing and vaccinations, maybe the end is near. Who knows? It's a moving target, certainly. But last year, and I think we did some webinars on this too, quite a few of you are aware that the Ministry of Human Resources and Democratization came out with some guidelines for employers. And it did a couple of things. It allowed the employers to put their workforce on remote working. And that seemed like a natural thing to do, but it was in fact a big step. It was the first time that employees were allowed formally and officially with official sanction to work from home and still be considered as normal employees. And, you know, I don't know, our firm, we were working from home 100% for 3 weeks and then trickling back into the workplace in small numbers after that. We're back up to pretty much full force now, but I know a lot of companies aren't. And, you know, many companies still out there have their workforce working largely from home or 50% from home or whatever. There were provisions introduced on giving paid leave to employees, which is just, you know, paid leave is a normal part of the landscape, but there was a little more flexibility given to put your employees on paid leave if they weren't able to work because there was no work to do. There were also provisions, accommodations on putting employees on unpaid leave, so you could reduce your, you know, payroll overhead temporarily, not firing the employees and sending them home, but keeping them on your payroll, but just not paying them. Again, the objective being to save the business and retain talent at the same time. But there are also provisions on what do you do if the employees are dismissed. And last year, you know, from March 19th onwards, here in Dubai at least, the airport was closed. You know, you couldn't go home if you wanted to. And to take cognizance of that fact, the ministry, in its guidelines and its resolutions, allowed employers to terminate employee services, but provided that until they could go home, they would have to keep on receiving their benefits. Not salary, but the other things like housing, like insurance coverage, and all the rest of that. And now that resolution has not been formally repealed. It still is in effect the way it was originally going. This is Resolution 279 of 2020. But now the question is that really how things are? Can we give notice? You have employees out there who are, you know, you want to downsize, there are redundancies, there's all kinds of reasons to reduce workforce. There can be, of course, reasons for termination with cause. And the question is, must you then keep these employees on your visa until they choose to either go home or find new employment in the local market? And again, this is a little bit of a difficult question because in a formal sense, the answer is yes. The old regulations haven't been changed, but everyone knows that they were there because of the fact that the airport was closed, no longer the case today. So it is an issue that I see coming up quite a lot. And it's a difficult one, how to guide clients who are employers. There are not a lot of employees who want to stay around indefinitely and look for work, but a lot of them do. A lot of them want to finish the school year. So that issue which has come up in employers is still coming up. And there's really no official guidance yet on how to go about addressing these situations. Another issue that's come up, and I'm only going to talk about one other issue here, is now the availability of the COVID vaccine. And if any of you, probably some of you are in Abu Dhabi, I know that you are from the list, you will have seen recently some guidelines coming out from the government of Abu Dhabi and from some of the big project owners in Abu Dhabi that are requiring, well, I'll go with the project owners first. They are sending out notices to the public that contractors are going to be required to make sure that their workforce who are coming to sites are tested on a regular basis or are vaccinated. And the question then arises, well, what if you are a company and all of your work is with, you know, a big government sector project owner? Can you then pass along this same requirement to your employees that they must be tested, you know, every week or vaccinated? This is an issue that's coming up now. Now, in a formal sense, you probably don't have anything in your workplace guidelines that says the employer can terminate an employee who doesn't get vaccinated or tested. But if all of your work goes away, or the only job you have is on a project that requires testing or vaccination, you probably have a pretty good basis for giving those employees notice of termination, probably under, you know, Article 117 with 1 month's notice and all that. But the issue, again, no one is going to seek termination. No employee is going to say no to an employer who requires them to be vaccinated or tested. It's just not happening. But if it were to come up on those isolated cases, I think the employer's position is pretty good. Now, also, in addition to project owners, we're seeing the government of Abu Dhabi as a whole and landlords are requiring that visitors to malls or tenants in buildings must, again, either get vaccinated or show that they're being tested on a regular basis with the approved COVID tests. Again, if you're not able to go to the office because the premises require testing and vaccination, that also might be the kind of thing that eventually becomes an employment issue. I think it probably won't in most cases, but every now and then it will. But I think looking forward, we can see the issue coming. I think looking forward, it's going to be the case that by summer, I expect that very, very large numbers of the population are going to be vaccinated. And it's probably going to be a requirement to keep your job, or for employers to keep people on the payroll, that they likewise comply with the vaccination. It's not being required in a formal sense yet, it's being strongly encouraged. And I think we're going to see it move from strong encouragement to requirement during the course of this year. That's what I expect. It's going to become an employment issue too. Let me think of anything else. You know, working from home apparently is still part of the landscape, which is a great thing. For those people that can what we do, working from home is great for lawyers and accountants, but some people have to go out and dig ditches and pour concrete and things like that. And I think that's really all I'm going to say about COVID. It's very much a moving target. We're moving towards requiring, vaccinations are available at no cost, which is a great thing. And I think more and more they're going to become required. And that's going to certainly change the dynamic in the workforce. Hopefully it goes beyond this current crisis that the economy has been facing for the past 10 months. And folks, that's the end of my prepared remarks. Danielle?
Yeah, I think we
have questions. Yeah. I think we have a couple.
We have a few questions. Right. I will repeat them, and sure, you can decide. Have the lists of activities where no local sponsor is required been published yet?
Yeah.
No, the answer to that is not as yet. It's been thought, as I mentioned earlier, there's a later effective date for that that restriction to be lifted, which is the end of March. So, it's been discussed and it's been thought that possibly that extension has come into play because it will allow time for that list of activities to be published. But as of date, it has not been published.
Okay, has the DED launched the digital submission for UBO declaration submissions? For submission.
Do you want me to? Yeah. So I think this varies between economic departments in different emirates. As for electronic submissions, I know that in Dubai at the economic department, we certainly have not been filing electronically. We've been presenting paper copies of registers to the Dubai economic department. In Abu Dhabi, I don't believe there is at present a way to file electronically or in hard copy. So it really varies between economic department. If you haven't been notified of the requirement to file, it's worth double checking and at the very least still maintain your register as per the resolution until such time as you are notified to file.
Yeah, the position is kind of funny because in DIFC, you're required to have a register of UBOs, but you're not required to file it unless they ask for it. They'll ask for it if they get requested for that information by a regulator from either in the UAE or overseas. But you have to have it, but not necessarily file it. But that requirement is different in different jurisdictions within the UAE.
I think I would add with the cabinet resolution, because it was published and then it literally came into effect pretty much the next day or quite quickly thereafter. And so what our initial findings were that a lot of free zone authorities and economic departments hadn't actually had the opportunity or hadn't really put in place the systems, and that's why there's been a lag in timescales. There have been, as I mentioned, some free zones which have always been requesting, non-financial free zones that have always been requesting such information, such as the DMCC. And so really for those free zones, it was more of just trying to align what information they had been historically requesting with what is now required under the resolution. Whereas for some free zones, it was actually starting from scratch and building that regime.
I think as you mentioned on the other DMCC, I think Jebel Ali is also taking online filings.
Yeah. Yes,
So,
that's right. Yeah.
Okay, going back, another question, going back to the LLC, this is a multi-question question, so I'll start,
I'll share.
When will the LLC companies, when will the amendment for LLC companies and 100% LLC company or 100% ownership without local sponsorship be effective? And is this covering Abu Dhabi or only Dubai?
Okay.
That's one part. Yeah. Why don't you part? Yeah.
So for that one, that deletion of Article 10, which requires the 51% UAE national ownership, that deletion comes into effect at the end of March this year. So it's not in effect as yet. What was the second part of that question?
And does it cover Abu Dhabi or Dubai? It covers
both. It's a federal. It's an amendment to a federal law, so it applies across the UAE.
And the other part is, are the new amendments for branch office effective now? And is there a need for a local agent? I don't know if
that's the same question. I think the first one is.
Yeah, for the branch offices, again, it's 31st of March 2020. A branch office or representative office. Sorry, I'm in the wrong year, thank you. A branch office or representative office of a foreign company will no longer require a local service agent. So end of March for that as well.
Yeah. But, it's important to mention a couple of things, bear in mind a couple of things. We think there's going to be some, you can form an LLC perhaps with 100% permanent shareholding when this takes effect. But that doesn't mean you're going to get the license you want, because licensing is still going to be an emirate by emirate thing. And there could very well be different rules in Abu Dhabi and in Dubai as to which kind of companies for certain activities must have a certain threshold of UAE national ownership. If you're in Abu Dhabi, for example, well, let's start with a federal law, the commercial agencies law, right? I mean, you've got to have majority ownership there, or you can't qualify as a commercial agent. There are quite a few businesses where majority UAE ownership is required for a certain kind of licensed activity. And that's probably not going to change. And so you might very well have, one set of requirements, if you want to call them that, applicable in one emirate and different requirements in a different emirate. And that's just part of the federal nature of the UAE. And the other thing to bear in mind is that if you're an existing business, you've got a sponsor, you've got a 51% shareholder, you also have in place binding agreements, right? You can't just walk away because the law is different. You've got a contract, the contract is enforceable. If you're going to restructure, you've got to do it in accordance with the contracts to which you're already party. And so that's just, I think the new law gives you it might give some relief for new businesses. For existing businesses, it might provide an opportunity to restructure. But and some companies, I think, or some sponsors would be very happy to restructure. But some, you got to raise the issue tactfully. Let's put it that way.
I guess I would just add two other comments to that, and that is that you'll remember under the old 2018 FDI regime, which now has been fully repealed under the decree law, not only were there there were certain conditions that were attached to licensed activities. So you might have been able to have a higher percentage as a foreigner ownership of your company, but that would come with conditions as to emiratization requirements, and injecting of a certain level of capital into the business. So those are other things to watch out for. It will not necessarily just be that tomorrow or with effect from 1st of April, you can suddenly own 100% of your business onshore. It is likely that there will be similar conditions to the former FDI regime put in place too. So that's one to watch out for, always linked to licensed activities.
Okay, next question. Are there any adjustments to the capital of the LLC, and is there any determination of the minimum capital required to establish the LLC?
That was under the 2015 law, actually, I believe the amendment was made, which allowed LLCs to operate with sufficient capital for the purposes of their business. So there wasn't, in law, a minimum requirement. Generally, companies are formed with 150,000 or 300,000 dirhams capital, just on a general basis, but that is what the law states, and that was under the 2015 law.
No one has changed.
No.
I think, the next question may be a repeat. Since the government has announced that that it is dispensing with the 51% national ownership requirement altogether, except for certain restricted sectors, when is it likely to be published? Also, are the different emirates given power to determine the local ownership requirements?
I think we answered that.
Yeah. So that was.
Hopefully that's clear.
Yeah. Okay. I
have a question, actually, because you talked about the preemption rules, for LLCs, and also how changes in shareholding prompt UBO filings too. How do those work? How do they work together? So you have an LLC, and you want and somebody wants to leave. I want to go. I want to leave my LLC, and I want to sell my shares, and you're going to buy them back, or someone else will buy them. Someone buys them. Okay. Yeah.
So any changes to the capital of the LLC have to be notified under the UBO resolution within 15 days of that change. On a transfer of shares, as described in that instance, what would need to take place is that under the resolution, the transferee would be obliged to confirm whether this is going to result in a change of beneficial ownership. Okay. That's what the resolution provides. You then need to update the register and file it if you can do so.
And that's on the management of the company, though, the updating requirement, right?
Correct.
Okay. But isn't there's also some kind of relief in the company's law from the preemption requirement? How does that work?
Yeah, so that relief is for a partner of an LLC to essentially apply to court to have a waiver of the preemption, or the statutory preemption rights under the 2015 law. That relief has to be sought on the basis that the LLC needs funding in a sort of emergency situation. So it's essentially to avoid the LLC going into bankruptcy.
Okay, so I'm going to call on a new shareholder because I need the funding really bad, and if my co-shareholders don't waive the preemption, or it won't stop the financing from going forward. Okay.
Correct.
Right.
Yeah.
Okay.
And I guess it's just to reflect, what's happened in the last year and the economic climate for a lot of businesses here.
Yeah. Okay.
Yeah.
I think we don't have any more questions from the audience, but I do encourage everyone, if you have questions that you haven't submitted on today's webinar, you can send them directly to Charles and Danielle, or you can send them to Kirsten from marketing, who was communicating with you on this webinar, and we're happy to answer them following the webinar via email or any other form.
Can I ask one more question now?
Sure.
Because Danielle talked about dispute resolution provisions. So you got to specify them now. But are you free to pick, I want the law of Norway and I want Norwegian courts? It must be local law, local courts.
I think if you selected foreign law, you'd have an issue with notarization and
Oh, okay,
registration.
like always, okay.
Yeah.
But can you pick like the IFC law, or must it be onshore courts?
I think it would need to be onshore still. Yeah, it's just a requirement to actually specify to the extent that you haven't specified already.
So
But
no
I
one's
believe-
school, huh? Okay.
Yeah.
Yeah, okay.
Yeah.
The rule always was, the default rule was always, it's local law, local courts, whether you say so or not, right?
It doesn't go into that level of detail, but I would expect that position to remain unchanged. Yeah.
So anybody, as I
Nothing
mentioned,
else?
Yeah.
Okay, yeah, good, okay. Well, I don't know, all you people out there, what do we have, 70? Wow, we got a pretty good, we got pretty good participation. Thank you for your patience, thank you for your interest and participation by with the questions. And, we enjoy doing this, and if you wanna hear us again, just keep on watching this space. We'll try and do more things with the CBC and also with the ACC. There's a lot to talk about as lawyers in the UAE nowadays. Things are happening and happening very quickly. So, we're trying to get out there with events like this as often as we can. So thank you very much.
Thank
you.
you. Thanks.
Okay.